Good afternoon. We are back after a lunch break. We have reached the 1 p.m. public comment session in EIB 21-27. We have several folks who reached out to the board administrator to offer comment. If you are on the platform and did not reach out to the administrator by email, that's fine. I encourage you to reach out through the chat, and I would be happy to take your comment. If you have any trouble with the chat function, please contact the administrator at 505-660-4305. The public comment is taken under oath pursuant to the board rules, is taken by audio, not video, and is limited to 5 minutes. The speakers I'll call on first are Jerry McHugh Jr., Khalsa Saraswati, Jeannie Stevens, Liz Stefanix, Holly Steinberg, and Antoinette Reyes. Let me start with Mr. McHugh. Hold on here. All right, Mr. McHugh, I have unmuted you. Can you hear me?
Yes, I can.
Oh, good. I can hear you. If you would please spell your name for the transcript.
It's Jerry, last name MC, capital HUGH, comma, Junior, JR.
Thank you. If you would raise your right hand, do you swear or affirm to tell the truth?
I do.
Thank you very much. I'll start your 5 minutes now.
Okay, thanks. Well, thank you for the opportunity, Felicia, and for the listening people. My name is Jerry McHugh Jr. I own and operate San Juan Resources, a New Mexico corporation since 1990, and I've been in oil and gas for my entire career. After having worked in Farmington, Dugan Production, and General Rome McHugh Sr. in the 1980s, I formed my own company in 1990 with operations in the San Juan Basin. We operate 40 wells, have non-op interests in several hundred, and have exploration and drilling projects. You might say that oil and gas is in my blood, as I've relished these opportunities to explore for and produce oil and gas. It's not for everybody, as the risks and challenges are formidable. Most of San Juan's production are marginal gas wells, where production averages less than 60 MCF of gas per day. We're able to operate cost efficiently and effectively, being more profitable when gas prices are above $3.50 per MCF. We don't choose the price we sell our natural gas and oil production. We are price takers at the mercy of markets. For the past 40 years, I've been positive about the oil and gas industry and continue to have that optimism for our natural gas and oil prospects in New Mexico. Marginal wells, and I'll talk about them a bit here, are usually held by independents, holding acreage for further development, deeper, newer technologies, and developing concepts for increasing production. The Mancos gas and oil drilling in the San Juan are excellent examples of small companies producing marginal wells, thus holding leasehold acreage for development. With new technologies, these wells could not have been drilled 20 or 30 years ago, maybe not even 10 years ago. But as the knowledge and technologies advance, these marginally held leases become more viable as independents utilize new science, engineering, technological know-how, and take on risks to grow and drill production. As longtime New Mexico Permian producers can attest, how has this worked with long-term leases and marginal wells eventually proving up sizable horizontal drilling projects with advanced technologies to get the Permian to what it is today. With highly stringent, overregulated, over-the-top methane rules, the state will quench that innovative spirit and technology-driven advances in future drilling and production growth. Long term, this will be devastating to the state's economy. With the Permian production in New Mexico be what it is today, had there been huge excessive regulations 10, 15 years ago? No, it would not be the Permian that it is today. Prior to the recent proposal for the EIB, New Mexico independents had worked with the New Mexico Environmental Department and the Oil Conservation Division through the Methane Advisory Committee to cobble an agreement where marginal wells would be exempt from methane regulations. When our company does cost-benefit analyses, it doesn't make sense to spend excessively on a gas well that A, leaks negligible amounts or minute amounts, B, that costs exorbitant amount to mitigate, making the well largely economic, and C, takes away valuable marginal production from the state severance taxes, shrinking state revenues. Do not put excessive over-the-top regulations onto already struggling marginal natural gas wells or oil wells, as this will quench those leases which could yield additional oil and natural gas like the next Permian or the next San Juan Mancos. All of American modern conveniences and lifestyle are attributable to the abundance of affordable, reliable, plentiful energy, primarily natural gas and oil, which we've enjoyed for more than 150 years. We wouldn't be the country we are today without the rule of law and free enterprise, which gives risk takers like me the ability to explore for and produce natural gas and oil. How many of us have seen the billboard that says, if you can read this, then thank a teacher? Well, let's look at this from an American energy perspective. If you value driving your car to the store for food or other items, or you value turning up your thermostat for heat in the winter or hot showers, or you value your handheld computer and the things in cloud storage, or you value traveling across the state or other parts of the US or the world, then thank a natural gas and oil producer. I really appreciate this opportunity to share with you today. That's my testimony. I'm Jerry McHugh Jr. with San Juan Resources. Thanks, Felicia, and thank you for all who listened. Bye-bye. Have a great day.
Thank you very much, Mr. McHugh. Go now to Saraswati Khalsa, and if I am mispronouncing your name, please correct me. Hello, can you hear me?
Hi, I'm sorry I can't figure out how to use the video.
Video is not available. If you would please spell your name.
Sure, my name is Saraswati, all one word, Saraswati, and my last name is Khalsa, Khalsa.
Thank you. If you would raise your right hand, do you swear or affirm to tell the truth?
Yes, I do.
Thank you. I'll start your 5 minutes now.
Thank you. Good afternoon, and thank you for the opportunity to provide comment. My name is Saraswati Khalsa. I live in Espanola, and I'm speaking today on behalf of New Energy Economy and also as the mother of 3 children. 3 children who will live with the consequences of the decisions that you make. If we do not adopt the most stringent leak detection and repair rules, if we ignore the science, ignore the pleas of the public, ignore the fact that 70% of the oil and gas industry's methane emissions in New Mexico stem from these leaks. By my calculation, that's at least 700,000 metric tons. My children and all the children in New Mexico and beyond will suffer the consequences. New Mexico's current administration likes to talk a big talk on climate action, trumpeting far and wide that they are committed to enacting, quote, nation-leading methane emissions rules, but all too often kowtowing to NEMOGA and the oil and gas companies and lobbyists who clearly feel confident that they have the government in their pockets. As Greta would say, nation-leading emissions rules, blah, blah, blah. Those words mean nothing at all until and unless our government regulations have real teeth and are strictly enforced. Until and unless those of you with decision-making power stop listening to the companies profiting off the destruction of our children's future, their very lives, and use your power for change. Until and unless emissions start decreasing in a meaningful way. And that will only happen if you have the courage to mandate frequent LDAR inspections and fast track the installation of zero bleed and zero emission pneumatic controllers for all oil and gas wells. no matter the size or how marginal they are. Leaking methane is not only a threat to all of humanity, but ozone precursors affect the health of the many New Mexicans who live in close proximity to oil and gas wells. They are so often our Native American neighbors, especially in the San Juan Basin. The department owes a maximum duty of care to those on Indian lands because, remember, every single oil or gas well, every pipeline, every compressor station and processing plant, every one of those oil company assets, they stand on lands that were the home of the first people. We can already feel our climate changing. We feel the excessive heat. We breathe in the wildfire smoke. We see the dried up rivers. Will we wait until the fields can no longer produce enough food for our children before we act? I hope you will not. Unlike most of us, you have the power and the responsibility to make meaningful change. I hope, for the sake of my children and all the children of New Mexico, that you will use that power for more than lip service. And you will enact the most stringent leak detection and repair rules. Thank you again for this opportunity.
Thank you, Ms. Carlson. We go to Jeannie Stevens next. Let's see. I believe I saw her. I've unmuted you. Can you hear me?
Yep. Can you hear me?
Yes, I can. If you would spell your name for the transcript, please.
My name is Jeannie Stevens. It's Genie, S like Sam, T like Tom, E, V like Victor, ENS.
Thank you. If you would raise your right hand, do you swear or affirm to tell the truth?
I do
Thank you.
swear to tell the truth.
I'll start your 5 minutes now.
Thank you. Hello, and my gratitude to the Environmental Improvement Board for providing an opportunity for me to testify at this hearing. My name is Jeannie Stevens. I'm the Director of Climate Education with the Rio Grande chapter of the Sierra Club, and I run a climate science, arts, and advocacy program founded by kids called the Global Warming Express in public schools throughout New Mexico for 4th through 6th graders. Now in its 9th year, the program gives children access to environmental education and teaches them how to become civically engaged citizens. The last time the New Mexico legislature went into session, 500 global warming expressors attended to listen and to give testimony. Our children are disproportionately impacted by pollution from oil and gas operations, including ozone-forming toxins that worsen respiratory diseases and trigger asthma attacks. Ozone or smog can also worsen emphysema and cause heart disease. We at the Global Warming Express, or the GWE, usually let the kids do the talking, but they're all in school right now, so they can't attend this hearing. I asked some of our Global Warming Express students, ages 10 to 13, from various parts of New Mexico for their thoughts about this hearing on ozone and methane levels in the air. Their replies reflect their intense concern for the bigger picture, their future. Here are some of their responses. Leaders of New Mexico, you have power. You can make laws happen. What on earth are you grown-ups doing? We need your support. There are ways we can slow down and stop the climate crisis. Please stop taking profits from oil and gas corporations. We children are fed up. If I could miss school today to talk with you, I would, because I don't want to watch our future go to waste. Another student said, we care about our future and our kids' future and our grandkids' future. We don't want our lives to be destroyed, and we want a healthy world. Remember, you are our representatives and not representatives of the oil and gas companies that are ruining our lives. And finally, the final student said, the earth is very fragile. We have so many problems, including extinction of plants and animals and air and water pollution. It's unthinkable that people are still refusing to stop the leaking of methane. It's hard to understand. There's a disconnect somewhere. In the midst of political and economic wrangling, I implore you all to pause and remember the children. Thank you very much for allowing my testimony.
Thank you, Ms. Stevens. Senator Stefanik, I've unmuted you. Can you hear me?
Yes, I can.
Oh, good. Your voice is nice and clear. Would you spell your name for the transcript, please?
Yes, Elizabeth, Elizabeth, middle name Liz, last name Stefanics, Stefanics.
Thank you. And if you would raise your right hand, do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your 5 minutes now.
Thank you. It's a pleasure to be with you all this afternoon. I'm speaking as the state senator from District 39, which is parts of 6 counties. And I am trying to speak here today to represent my constituents. I have a lot of knowledge about the energy field, and I realize that the fossil fuels needs to be in existence with our renewable energy for the foreseeable future. But while we continue to do that, let's protect not only the environment, but let's really protect the people who live close to the working establishments for the fossil fuels. Now, most of my district is rural, and I would say that many of the people in my district don't have the opportunity to really come to the legislature to speak, to get on a computer to speak, because the internet services in many parts of my district are non-existent. When the children have to go to school, the parents drive them to a hotspot, you know, the libraries or Walmart. But today what I want to talk about is those individuals who live close to a site. While I was a county commissioner, we dealt with many renewable energies. We dealt with oil and gas prohibitions, we dealt with wind, we dealt with solar, and I myself live in a rural area. One of the things we tried to do is we tried to put science behind our decisions on how far away the production could occur in order not to harm individuals. Even when we were going to go into areas where we would do any kind of, I'm losing the word for exploding materials, but whether it was gravel or whether it was fracking, we wanted to make sure that we were doing it in such a way that we were not harming the surrounding communities, that the air quality and that the water quality would remain. So one of the things I would recommend is that there be frequent inspections, that we protect those individuals within a certain circumference, whether it's a half a mile or a mile, and we probably could not accommodate the mile anymore, and that we do some sampling of air and water in advance in order to acknowledge whether or not there is harm made later on during production. I believe that's all I need to say today, and I appreciate all the work of the EIB. Thank you and have a great afternoon.
Thank you very much, Senator. Go to Holly Steinberg. Ms. Steinberg, can you hear me? Ms. Steinberg?
Yes, I can hear you. Can you hear me?
Yes, I can. If you would spell your name for the record, please.
Holly, Holly, Steinberg, Steinberg.
Thank you. And if you would raise your right hand, do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your 5 minutes now.
Thank you very much. I live in Albuquerque, and I believe we have an obligation to our future children. I also believe we can do that while still supporting the industries that support our state. I think the intention of making improvements in how we capture and utilize our natural resources is very important. And to think that those who support the oil and gas industry also don't support the environment, that's short-sighted. When we are making improvements in the process, we have to be mindful of a fine line we need to walk to pay attention to the economic factors as well as the long-term benefits of our future generations. So our state spends on depends on the production from the oil and gas industry to the tune of about $1.3 billion. This accounts for over a third of our state's budget. Those monies go towards schools, infrastructure, healthcare, and public safety. So many of our oil and gas producers are smaller producers in the state, and there are 35 proposed new requirements that can be very crippling to these smaller producers. Even though there are businesses that are excluded that produce 250,000 gross revenue, they don't have to participate, but that still does not take into consideration the small producers who might have more gross revenue than that, but the costs would be crippling if they were have to comply with those 35 regulations that are proposed. One area that is of specific concern to me is the impact of recycling the produced water from the oil and gas operations. Right now, they use the recycled water, but this new proposed rule does not take into consideration that rule. And so it would allow fresh water to be used for that, which I believe is wasteful. If we're going to be flexible in implementing our new administrative requirements that are being proposed in this rule, this would allow businesses to continue to work toward improving, but by doing it through sharing best practices and implementing improvements that would make a more practical approach as opposed to a cookie cutter approach, making every single company comply exactly the same. If we do this in stages and we consider improvements that are being made, I think that's much more feasible approach to making improvements that I think is the intention of this ruling. So bottom line, I think anytime we're in the process of making changes for any business, you have to continue to improve our processes, but not do it at the detriment of the greater good. And the people that will pay for this ends up being the citizens and the business of our state. I think it's more feasible to take a staggered approach, a slightly less aggressive approach, and one that's a little bit more informed. Thank you so much for your time and your consideration.
Thank you, Ms. Steinberg. Go next to Antoinette Reyes. Let's see here. Ms. Reyes, I've unmuted you. Can you hear me?
Yes.
Oh, good. You're coming through nice and clear. Would you spell your name for the transcript, please?
Antoinette, Antoinette. Reyes, Reyes.
Thank you. And raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Thank you. I'll start your 5 minutes now.
Hello. I'm speaking on behalf of myself today as a 15th generation New Mexican and a mother of two in southern New Mexico. Thank you for considering my comment today. I fully support the proposed ozone precursor rules and their goal of protecting those that live closest to development. Much of my family has been impacted by the disproportionate impacts of extractive industries. These industries tend to drive up the cost of living in areas while only bringing low-wage service jobs outside of industry, creating a wider income gap. Aside from displacing people by income, the high wages offered by industry come with numerous health and safety risks. My hope is that these rules will lessen the burden these risks have on workers, our children, our elders, and residents that live in impacted communities. I also want to thank the department for accepting the proposal to include increased inspections based on proximity. This proposal will help strengthen the rule, and I hope the board adopts other proposals to protect New Mexicans, such as the proposals around completions and zero bleed pneumatics. Thank you.
Thank you very much, Ms. Reyes. Let's see, Mr. Sontag reached out asking that I look for Melanie Leahy. I'm sorry, I don't see Ms. Leahy on the platform, and I don't have any unidentified callers. Mr. Sontag, if you would please let Ms. Leahy know that she can submit her public comment in writing to Pamela Jones, or join us tomorrow at 9, 1, or 5, or even today at 5. So thank you all for participating in public comment today. And at this point, we will return to the technical case. Mr. Bach, are we going to Dr. Orozco, or will that wait?
Yeah, we'll go ahead with Dr. Orozco. I believe he should be on and perhaps even already made a panelist.
Yeah, I'm here. Can you hear me?
Oh, yes. There you are, Dr. Orozco. Madam Hearing Officer, in light of the discussion we had before lunch, I think we will go ahead and withdraw Exhibit 28. It's information we wanted to do. It is largely a summary of statutes and regulations which would be subject to administrative notice anyway if you want to do that. We'll go ahead and withdraw that. I don't think there were any objections to Dr. Orozco's seat. 27.
Mr. Backey, I'm sorry, you're cutting in and out for me. Could you please repeat?
Yes, from the beginning.
Please, sorry.
Sorry. Madam Hearing Officer, in light of the discussion we had before lunch, I think we will withdraw Exhibit 28, which is largely a summary of statutes and regulations that we think we can introduce by administrative notice. I don't believe there were any objections to Exhibit 27, which is Dr. Orozco's view.
Let me pause for a moment in the event a party wishes to lodge an objection. Not seeing anyone. Exhibit 27 is admitted. Oh, and Dr. Orozco, I believe I need to swear you. Would you raise your hand? Oh, first spell your name. Okay. Now you're unmuted. Please spell your name.
Sure. My name is Daniel Orozco. Daniel is the standard spelling for Daniel, and last name is Orozco.
Thank you. Raise your right hand. Do you swear or affirm to tell the truth?
I do.
Thank you. Mr. Bach.
Thank you, Madam Hearing Officer. Dr. Orozco, what is your educational background?
I'm a physics engineer by training, and I also completed a master's degree and a doctoral degree in atmospheric physics at the University of Maryland, Baltimore County.
And what is your work background?
For more than 12 years, my research and work has focused on the study of chemical and optical properties of air pollutants, the development of instrumentation to analyze pollution, as well as the study of sources and impacts of air pollution. I work as research assistant at the University of Maryland, I then work in the Air and Radiation Management Association at the Maryland Department of the Environment, and I currently work at the National Parks Conservation Association as the Senior Clean Air and Climate Analyst.
And National Parks Conservation Association is part of the Clean Air Advocates Coalition, correct?
Yes, that's correct.
Clean Air Advocates Exhibit 27 is an accurate copy of your CV.
Yes.
Dr. Orozco, can you please summarize your testimony?
Sure. The purpose of my comment today is to explain why Clean Air Advocates oppose certain changes that NMED made to the engines and turbines provisions as part of its rebuttal testimony on September 7, 2021. Engines and turbines are by far the largest source of NOx from the oil and gas industry. As we heard earlier in the hearing, ozone formation in New Mexico is often NOx limited. Accordingly, reducing NOx from engines and turbines is an important strategy for reducing ozone levels in New Mexico. We are particularly concerned about two aspects of the revised proposal. First, the proposal will delete the prior requirement that engines or turbines installed after the effective date of the rule meet the emission standards applicable to new equipment.
Madam Hearing Officer,
Mr. Heiser?
the changes that were made were advocated by NMOGA in its direct, and the appropriate time to respond to NMOGA's arguments that those changes should be made would have been in rebuttal, not in sur-rebuttal for the first time.
Madam Hearing Officer, we were providing sur-rebuttal to changes that the department adopted.
That was my understanding as well.
We didn't provide any testimony before because we agreed with the prior proposal.
Yeah, that was my understanding. Please go ahead. And Dr. Orozco, if you would please speak slowly.
Sure. We are concerned that this provision might make New Mexico a dumping ground for old high pollution equipment that is no longer allowed in other states. There is no reason an operator constructing a new or modified facility in a high ozone area of New Mexico cannot use a state-of-the-art equipment. Second, we believe that the standards for existing four-stroke lean burn engines in particular are not protective enough. Last year, Colorado adopted a standard of 1.2 grams of NOx per horsepower hour for these engines. The Colorado Air Pollution Control Division found these standards to be cost-effective and achievable. While NMED has adopted an appropriately stringent emission limit for larger four-stroke lean burn engines, those with a rated horsepower of 1,775, its emission limit for medium-size four-stroke lean burn engines with a rated horsepower between 1,000 and 1,775 is too low. NMED's revised standard is 2 grams of NOx per horsepower hour, which is 40% higher than the Colorado standard applicable to these same engines.
Thank you, Dr. Orozco. Are there any other jurisdictions that have adopted emission standards for these existing four-stroke lean burn engines that are more stringent than the ones the department has proposed here?
Yes, many other states or local agencies have adopted more stringent regulations for existing engines. For example, Texas has adopted a standard of 0.7 grams per horsepower hour for existing lean burn engines within the Dallas-Fort Worth ozone non-attainment area. Those standards can be found at 30 Texas Administrative Code Section 117.2110. Pennsylvania's standard for these engines when installed at new or modified facilities is 0.5 grams per horsepower hour. In addition, many air districts in California have even tighter NOx emissions limits, with some requiring emissions as low as 0.15 grams per horsepower hour.
Thank you, Dr. Orozco. And I just wanted to clarify, when you're talking about these standards, we're only talking about NOx or NOx, correct?
Yeah, that's correct.
And we are clean air advocates objecting to standards for carbon monoxide, for example?
Can you repeat? I'm sorry, I couldn't hear that.
Are clean air advocates objecting to the proposed standard for carbon monoxide?
No.
Okay, thank you. Did you see any evidence in the record as to why this speaker standard for existing four-stroke lean burn engines was appropriate here?
No, I reviewed the other party submissions and did not see any justification as to why the higher limit of 2.0 grams of NOx per horsepower hour was proposed here. In fact, the analysis submitted by NMOGA stated that some retrofitted legacy engines can currently meet 0.8 grams per horsepower hour NOx, but that the cost to bring the emissions rate at these units down to 0.5 will be excessive. That analysis further stated that most state regulatory agencies recognize the challenges for engines made prior to 2007 to meet sub 1.0 grams per horsepower hour emissions levels. There is no discussion of why these engines cannot meet a standard of 1.2 grams of NOx per horsepower hour, consistent with what is required in Colorado. NMED's discussion did not explain the decision to use a 2.0 gram standard either. NMED provided a table showing that 100% of the medium-sized existing four-stroke lean burn engines tested in Ohio were emitting at rates less than 2.0 grams per horsepower hour. That suggests that the limit is not nearly stringent enough. Notably, the rule contains numerous flexibilities to allow operators to continue using engines that do not meet the department's emission standards. For example, operators can reduce the annual hours of operation, can submit an alternative compliance plan that averages emissions across the operator's entire fleet of engines, and can seek exemption for particular engines that cannot meet the standard in a cost-effective manner. Including all of these alternative compliance mechanisms while setting the standard at a level that all of the subject engines can meet is inappropriate, because it means that our operators will not be required to implement cost-effective controls at all of their engines.
Thank you, Dr. Orozco. Do you have anything else to add?
Just to summarize my testimony, we respectfully request that the board first include the language originally proposed by the department that will apply the most stringent emission standards to engines and turbines that are installed after the effective date of the rule. And second, adopt emission standard for existing four-stroke lean burn engines that are at least as protective as those adopted last year in Colorado. Thank you.
Thank you, Dr. Orozco. With that, we will make Dr. Orozco available for cross-examination.
Thank you very much, Mr. Bach and Dr. Orozco. If you are a party with questions, please turn on your camera. I see Ms. Gutierrez.
Thank you, Madam Hearing Officer. Dr. Orozco, it's nice to meet you. My name is Ana Gutierrez with Hogan Levels, and I'm here on behalf of Kinder Morgan. I have just one, I think, clarification question for you. You referenced that in California, they may have adopted a lower NOx limit than is being proposed by the department here for four-stroke lean burn engines. Is that right?
Right.
And are you also aware, and I think what I heard you say is you referenced the limit that equates to about 0.15 grams per horsepower hour, correct?
Correct.
And are you also aware that that limit does not apply to lean burn engines used for gas compression, or those engines of limited use operations, or engines that are waste gas fuel?
No, I'm not particularly aware of that, but my understanding is that apply for four-stroke lean burn engines as well.
Thank you. I appreciate that. And I have no further questions for you.
Thank you. I see Professor Pisiniak.
Thank you, Madam Hearing Officer. Dr. Orozco, my name is Gabe Pisiniak. I represent the Center for Civic Policy and NAVA Education Project. I just have a couple of questions for you, and thank you for your testimony. Could you clarify, prior to the September 16th proposal, what was the department's proposal for four-stroke lean burn engines, and how did the department's proposal compare with Colorado's new standards?
That is, I believe, in table 2, 1 and 2 of the section 113. So can you repeat the question, specifically the four-stroke lean burn, right?
Yes, so I thought I heard you say that recommend the department adopt standards that were at least as stringent as Colorado's. Was that correct?
Yeah, which is 1.2 grams of NOx per horsepower hour.
And what were the standards? Are you aware of what the standards were that were proposed by the department prior to the September 16th revision?
It was 0.5 grams per horsepower hour, but it didn't specify the specific rated horsepower.
And so in the September 16th revision, is your testimony that the standards became weaker?
Yeah.
I see. And so would the pre-September 16th standards meet your recommendation for being at least as protective as Colorado standards?
Yes.
So if I understand correctly, you're just asking the department go back to what they had previously introduced?
No, we are not necessarily asking them to go back to what they introduced. There is not a direct comparison between what it was originally proposed and what it's now, because again, the rated horsepower is different. So what we are proposing is that they adopt for that same size of engines to adopt the Colorado standard, which is 1.2 grams per horsepower hour.
Thank you. I appreciate that. I have no further questions.
Thank you, Professor Pisiniak. I see Mr. Swift.
Thank you, Madam Hearing Officer. Couple questions for you. Good afternoon, Dr. Orozco. My name is Whit Swift. I'm an attorney for the Gas Compressor Association, or GCA. Couple follow-up questions based on your testimony. I believe tied to this use of the language about installed in the applicability section of the proposed New Mexico rule, you said you were concerned that New Mexico may become a dumping ground for old high polluting equipment. Is that correct?
Correct.
Now, existing engines will be regulated under the proposed rule, correct?
Yes.
And do you consider an existing lean burn engine that can meet 2 grams of NOx per horsepower hour to be old, high polluting equipment?
Can you repeat the question, please?
Sure. So existing engines, they're regulated under the proposed standard, correct?
Yeah. Mm-hmm.
And the proposed standard sets a limit of 2.0 grams of NOx per horsepower hour for those engines. Now, an engine that can meet 2 grams of NOx per horsepower hour, that's not an old high polluting engine, is it?
No.
Thank you very much. No further questions for the witness.
Thank you, Mr. Swift. I don't see any other parties on screen to question Dr. Orozco, so I'll turn to the board for their questions. While I'm doing that, in the event you're an attendee on this platform, please reach out through chat if you have a question. Madam Chair, do you have questions?
Yes, thank you, Madam Hearing Officer. Good afternoon. Thank you for your testimony, and I just want to clarify in my head here. So the rules that you are recommending are now the Colorado standards. Is that correct?
Correct.
Okay, and is that I think you referred to as going back to the May rules is not necessarily apples to apples because of the recent revisions. Is that correct?
Yes, because of the distinction between the size of the engines.
Okay, and so the difference in the September 2021 proposed rules would be a apples to apples comparison or revision with the Colorado rules. Is that correct?
Correct.
Okay, and I don't know, in terms of logistics and process here, have those rules been proposed as part of this section?
I'm not sure about the answer to that question.
Okay, all right. Well, thank you for your testimony. I appreciate that.
Thank you.
Madam Vice Chair?
Yes, thank you. Ms. Sweden asked the second line of questioning. I'm sorry, Member Sweden. So I wanted to just talk about the point, Dr. Orozco, that you brought up about the engines being moved and concern over old engines that wouldn't meet standards. And I believe in some previous testimony, and I apologize because I don't remember who gave the testimony, but it was mentioned that an engine had to be registered when it was put into date of service. As it came into the state, it needed to be registered when it was put into service. Does that satisfy your concern over that issue?
Well, first of all, I'd like to say that maybe a suggestion for the department is to make this completely clear because it could be really confusing. So clarifying that will make it easier for everybody and to make sure that overall NOx emissions are reduced overall from any source. But in summary, our concern is that all engines, say from another states, are brought in or bred into the states for operation. And if it's not clear, they may run and they may operate without the most stringent emission limits. So that's the main concern, that whether they are installed or relocated, the most stringent controls are applied to those engines, which are the ones given in table 2 of section 113.
Okay, thank you. I appreciate you clarifying that for me and for taking the time to talk with us.
Thank you. Member Cates, any questions?
No questions at the moment. Thank you.
Thank you. Member Bitzer?
No questions. Thank you.
All right. Member Garcia?
No questions. Thank you for your testimony, Mr. Orozco.
Member Hunter? All right. Did any of that prompt redirect for you, Mr. Bach?
No redirect. Thank you very much.
All right. Thank you very much, Dr. Orozco and Mr. Bach. Let's see, Ms. Katz?
Madam Hearing Officer, it may be appropriate for Mr. Lasowski's rebuttal after the NPS proposal before we go to the department.
Oh, that is just fine. Thank you, Mr. Heiser. Thank you, Ms. Katz, for turning on your camera. I believe I panelized Mr. Lasowski, so we should be able to see him. There we are.
All right, Mr. Lasowski, are you on? I am not seeing him.
How is that? Is that better?
Okay, I can hear you now. Oh, there you are.
Great.
Can you please state your name for the record?
Yes, it's Justin Lasowski, spelled Lisowski.
And you were previously sworn in this matter, is that correct?
Yes, sir.
And your testimony has been previously adopted?
That's correct.
And have you listened to the testimony of the other parties in this hearing on engines and turbines?
Yes, I have.
And did you hear testimony from the National Park Service regarding a possible expansion of this program to lower horsepower engines?
Yes, I did.
And did they withdraw that recommendation for purposes of this rulemaking?
Yes, that's correct.
And do you support that recommendation? And if so, why?
I do support that recommendation, and their recommendation that was withdrawn expanded the horsepower limits to a much lower and impractical limit that for us to actually manage or maintain. It had some infeasible targets that provided significant challenges, technical challenges, as well as costs associated with these extremely low limits on a pretty small horsepower range. For all of National Park Service's recommendations below 1,000 horsepower, this argument's been raised and refuted in other rulemakings, such as Colorado, that generally speaking, you can say that extremely low NOx limits may be initially achieved, but for various reasons, ballast degradation, AFR drift, other parameters, engine limitations, it just isn't something that is a sustainable limit to propose at this time.
Did you hear this most recent testimony from Dr. Orozco on behalf of National Parks Conservation Association?
I did, yes.
And do you agree with his comments on the achievability of lower limits for four-stroke lean burn engines?
As a broad statement, no, I don't agree with those. The memo that I supplied on behalf of Valor for NMOGA was really focused upon what is technically achievable in this space. NMED, I think, did an excellent job trying to distill down, what the desired limits would be. Everyone agrees that we want to approach this rule in a way that is beneficial environmentally for ground level ozone creation. But at the same time, we need to balance that with what is technically practical within the industry. And proposing NOx targets, since this is the general, criteria pollutant we're talking about in this context, if you propose something that's not achievable, then you're actually probably not going to be achieving the intent of the goal, because you'll be looking for exemptions, or you'll be shifting to alternative sources of compression driving capabilities. But we tried to balance out what was achievable in current technology. And in many instances, existing engines already have all those low emission control technologies, as I explained to the board, that limits your NOx input based upon lots of different engine parameters, vintages, architecture, size, and such that, those limits proposed by Mr. Orozco was not a blanket achievable target.
I think one of the limits he spoke to at some length was a 1.2 grams per horsepower hour. Do you have any thoughts on that limit?
I do. I'm aware that that's part of the Colorado Reg 7, and I'm not entirely savvy on that rule. I know it's pretty nuanced, and there's quite a few caveats, as Ms. Gutierrez mentioned. But generally, what that means is there's going to be a large subset of engines in New Mexico that cannot achieve that target and will need to be replaced either by new horsepower or potentially electric drivers, which creates a different type of emission source. It's not eliminating your emission source.
Thank you. That completes all of my questions. Madam Hearing Officer, we make Mr. Lisowski available for any cross.
Thank you very much, Mr. Heiser and Mr. Lisowski. I see Mr. Bach on screen and Ms. DeVore. Mr. Bach?
Thank you, Madam Hearing Officer. And thank you, Mr. Lisowski.
That's correct. Yep.
Okay. Just a couple of questions. I think you said that the limit we proposed of 1.2 grams of NOx per horsepower hour is not blanketly achievable or something to that effect.
That's correct. You put a broad blanket to put on all existing engines, all existing lean burns specifically can meet 1.2, and that just isn't true.
But doesn't the rule, as recently rewritten, allow for averaging across engines?
There's the potential for that, yet you do have to have an engine that can exceed your limit in order to have that averaging.
And there's also the ability to get relief for a specific engine that cannot meet the standard. Is that also correct?
There's provisions within the rule for your alternative emission standard as well as your alternative compliance plan, but that's not just a, you can do this. It does need to be reviewed, go out for public comment and all those things. So it's not just a statement that you just can average your emissions. It does need to go through the proper approval protocols, and we're not fully certain as to how that will work out.
And I appreciate that. I guess what I'd like to know is if there were, you know, a small number of engines that could not technically meet this standard, but you did have those flexibilities, would that allay those concerns?
I can't comment on that since I don't have the specificity of what you were referring to.
Yeah, I was just referring to the averaging provision that's included in the draft.
Are you referring to the alternative compliance plan?
Yes, exactly, alternative compliance.
Well, like I said, you know, we're not exactly sure how that's going to work out with the peer reviews as well as public comments. And so conceptually, it might prove to have the proper off ramps, but until we actually see it in practice, I can't comment on that.
Well, that's helpful. So I think that one other question I just wanted to make sure I understood. Any lean burn engine built after 2007 is going to be required to meet a limit of one gram of NOx per horsepower hour. Is that correct?
Under which standard? In SPS?
Yes, under the SPS.
You know, I don't have the NSPS rules directly in front of me on terms of what that limit is, but yes, the engines are regulated by NSPS.
Yeah, because I'm looking at your report for Valor, and I think you said, you know, the challenge really comes with the pre-2007 engines in terms of getting below 1.0 grams.
There's multiple categories I reference in the Valor memo, one being the legacy engines, as well as, you know, engines before 2007. For instance, you know, comment of some legacy engines being able to meet 0.8 grams that Mr. Orozco referenced. And that was actually referring to old legacy large bore engines that already had extensive LEC technology installed that would undergo a significant economic upgrade to get beyond that 0.8. And so that was for a capital expense argument.
All right, no further questions. I really appreciate it. Thank you so much.
You're welcome.
Thank you, Mr. Bach. Ms. DeVore?
Mr. Bach, he addressed most of my questions. I just have one remaining question for Mr. Bobrowski. I hope I'm not mingling your name. Thank you for your testimony. So I was just curious if you would consider 2 grams per horsepower hour to be a high emitting engine because of the NSPS rules at this point in time, because if that haven't been able to be sold in the US for the last 10 years.
You know, I think a high emitting engine statement is kind of a, you know, a general statement that it really depends. You know, I think it's somewhat of a subjective statement, but if you have a engine emitting beyond its regulated NSPS limit, you know, one could argue that it is a high emitting engine, but it depends on that reference. It's analogous to calling an engine a large bore versus a small bore. There's not exactly a definitive number which designates large bore versus small bore. So, you know, I don't think it does any justice high emitting versus low emitting. It wouldn't be a compliant engine if it exceeded NSPS.
And then just, I think one last question, I'm thinking about it. So as far as construction goes, so are you aware of, like, do engines, when they undergo construction, how long it might be before they're actually installed at a site?
You know, that varies significantly. It depends on what kind of site you're talking about. For instance, at my previous company, we would set multiple engines at the beginning of a tank battery facility, or we would wait to see if we'd need gas lift, and they would come on site 6 months to a year later, depending on what the well requirements are. So I would say it varies. For large plants, you're likely setting the equipment earlier on. during the construction phase, but it really depends.
Okay, that's all my questions. Thank you.
You're welcome.
Thank you very much, Ms. DeVore. Any other parties with questions of Mr. Lisowski? All right, I'll move to questions from the board. While I'm doing that, if you're an attendee on this platform, please reach out through the chat with any questions. Madam Chair, any questions of Mr. Lisowski?
Thank you, Madam Hearing Officer. Good afternoon, Mr. Lazowski. Did I say it right? I'm sorry.
You did, you nailed it.
Okay, Lazowski. Thank you again for your information and what you presented here today. So I just want to make sure I'm kind of wrap my head around it as well. I know you had said earlier that that you would need a engine to exceed the limit, and I think in this case you were saying one, right? One
lower than the limit, yeah.
Yeah, in order to kind of average everything out. And I was just wondering, are there engines available to exceed or do, better that limit?
Now, are you referring specifically to the table 2, the existing engines?
Yes.
Yeah, so they'll be, it's a tough category to work through because you're trying to make sure that you're offering enough flexibility technically so that you can, in practice achieve these limits. And so, yeah, there'll be engines within that category that can exceed the 2, but generally a lot of those will be in that maximum 2.0 grams without replacement. But it really depends because that's the really hard part with existing engines is you have the entire state fleet within this category, right? And so there's going to be some winners and there are going to be some losers. And in some cases, perhaps that there will be some opportunity to reduce, on an engine that's, for instance, a old legacy engine that has all this LEC technology. Maybe it can get down to 1.8 grams, or maybe it can get down to 1 gram. But as a broad statement, a lot of the horsepower that's in place, which is like the Caterpillar 3500, that's probably the most common in service right now in the gathering space. 2 grams is going to be the most achievable for many of those engines.
Okay, and then for new engines, is that level easier to meet? Just throwing that out there.
It is, and once again, it depends on what type of engine we have. But for instance, we were supportive of that 0.3 grams for greater than the 1875 because there's product offerings. Now, that doesn't mean that that's necessarily easy target, but it is more practically achievable, and that's where in my memo, that's what I'm trying to balance is what's trying to meet these limits. I'm in agreement that this is a good rule, but you also need to balance it out with what's actually possible so you're not shifting it to a different type of source, whether it be power plants to drive electric motors or whatnot.
And thank you for kind of leading into my next question. So I think you mentioned there were other jurisdictions that had stricter limits. In California, I think was mentioned, and Colorado. So are they running into issues in terms of meeting these new compliance or those amended compliances limits?
I can't speak to the the result of these rules, especially because they're fairly new, and I don't have any experience with California rules. I do have personal anecdotal experience where we were trying to, we had an old legacy Ajax compressor engine, and you guys have a lot of those in New Mexico. They're old legacy 2-stroke engines. And we needed to replace it. It was at a Title V facility, and right across the street was another operator's Title V facility. And part of NESHAP meant that we had to do fence line monitoring to meet the NACS rule, the NACS rule, not NESHAP. And we had a kit that offered by Ajax at the time. I don't believe it's offered anymore. They've gone out of business, but that lowered the NOx of that engine plus upgraded the horsepower. And we failed. We were not able to pass that modeling criteria because of the just the large emitting source from this Title V facility plus the operator across the street. And so what we ended up doing is, instead of making that Ajax cleaner and getting more horsepower, reducing our annual tonnage and achieving our needs, we ended up setting 2 electric motors as a result, so that we didn't have to get into our air permit, because it would have eliminated the grandfather status. And the point of that story is, that there are unintended consequences if you can't meet these standards. Not just that we'll magically meet them, it's just that we'll have to find alternative ways to satisfy them, and it might not be the intended outcome of a rule.
Thank you for that. And was that example here in New Mexico that you just?
No, that was in Colorado.
So that was in Colorado. So
Yep, that was a facility I had worked on at one point in my career.
okay, and how long ago was that?
That was probably in the 2012 to 2014 timeframe.
Okay, all right. Well, and at that time, were there these more stricter standards at that time?
No, but Colorado was going through some non-attainment challenges, so you would say that it was probably pretty strict, but it wasn't these rules that are currently in place.
Okay, well, thank you for that information. I appreciate it.
You bet.
Madam Hearing, thank you, Mr. Wazowski, and Madam Hearing Officer, that's all I have.
Thank you. Vice Chair Trujillo Davis.
I don't have any questions. Great line of questioning, Madam. Madam Suina.
Thank you. Member Kate.
No questions here. Thanks.
Thank you. Member Bitzer.
No questions. Thank you.
Thank you. Member Garcia.
No questions, thank you.
And Member Honker.
No questions. Thank you.
All right. Thank you very much, Mr. Lasowski. Let's see if any of the chair's questioning or the other party's questioning prompts redirect.
No, I don't believe so. Thank you, Madam Hearing Officer.
All right. Thank you, Mr. Heiser and Mr. Lasowski.
You're welcome. Thank you.
So I would like to clarify, are we going to hear from Ms. Cooper or Dr. McCabe and then go back to the department? Is that?
I believe, Madam Hearing Officer, that we would hear from all the other witnesses that are available before we go back to the department on the storage vessels.
All right. Mr.
Madam Hearing Officer, I believe, sorry to interrupt, but I believe Dr. McCabe is ready.
Okay, and I saw Ms. Gutierrez briefly. Will we hear from Ms. Cooper after that?
Sorry, that was accidental video footage. So apologies.
All right. Thank you.
And we also do have, I believe we have Mr. Kim and Ms. Cooper for CDG, do we?
I thought we already heard from Mr. Kim, maybe.
Oh, we did, you're right, sorry. I have Ms. Cooper listed as a rebuttal witness that has having provided rebuttal testimony, but maybe that, I don't know, they would have to answer that.
All right, I'll clarify after we hear from Dr. McCabe. Mr. Bach, and I am certain I made Dr. McCabe a panelist, so we should be able to see him. Oh, there he is. Hello, Dr. McCabe.
Hello.
I believe Dr. McCabe is still under oath. Oh, there you are, David. Dr. McCabe, can you summarize your testimony today?
Yes, I will be summarizing my direct and rebuttal testimony regarding storage vessels and then offering some brief rebuttal. And I also wanted to provide some information in response to questions I received from the board the first time that I testified on Tuesday. First, Chair Sweeney asked whether there had been a negative impact on the oil and gas industry in Colorado since the state adopted the nation's first methane regulations for the oil and gas industry. I will summarize my written rebuttal testimony, which showed that there had been no discernible negative impact. Second, several members asked for additional information about the benefits that can be realized by retrofitting natural gas-driven pneumatic controllers that are not captured in NMED's cost analysis And so I will briefly respond to that inquiry as well.
Thank you, Dr. McCabe. On the subject of storage vessels, NMED proposes to require emission controls at any existing storage vessel with a potential to emit at least 2 tons per year of VOCs. NMOGA proposes that the threshold should be increased to 6 tons per year. Why do clean air advocates oppose that change?
So several jurisdictions require control of emissions from storage tanks with VOC emissions lower than 6 tons per year. These include Colorado with a threshold of 2 tons per year for new and existing tanks, and Pennsylvania, which has required the control of all new or modified tanks with VOC emissions above 2.7 tons per year since back in 2013. Finally, since 2012, the US EPA has required any existing tank required to control emissions under NSPS Quad O or NSPS Quad OA has to retain that control until emissions drop below 4 tons per year. When Colorado lowered its threshold for control of tanks to 2 tons per year, the Colorado Air Quality Control Commission found that control of tanks emitting less than 6 tons per year of VOC is cost effective. In fact, the commission specifically found that control is cost effective even for the lowest emitting tanks in that cohort, those emitting between 2 and 3 tons per year of VOC. And then, of course, tanks with higher emissions than that are even more cost effective. Therefore, it would be inappropriate to raise the threshold for control of tanks from 2 tons to 6 tons.
Thank you, Dr. McCabe. And could you describe the proposal that Clean Air Advocates have made to include a storage vessel measurement requirement in this tank provision?
Yes. Clean Air Advocates propose to add a new subsection C to this section entitled Storage Vessel Measurement Requirements. This provision would mirror almost word for word an amendment to Regulation 7 adopted by Colorado in December 2019. And that specific citation is included in my written direct testimony.
What would be the purpose of this new proposed subsection?
So the new subsection, would reduce emissions from storage vessels installed at new or modified facilities by requiring those tanks to employ a storage vessel measurement system to determine both the quantity and quality of liquids in the storage vessel. Typically, in order to measure the level of liquid in a tank, operators open a thief hatch on top of the tank to insert a gauging device, and then operators also typically collect samples of the liquid in the vessel through the hatch. When the hatch is opened, of course, air pollutants, including methane, VOCs, and hazardous air pollutants are released. Since gauging is often performed quite frequently and the hatch is opened every time a measurement is taken, these emissions can be significant. Operators can avoid these emissions by employing an alternative system to measure and sample the liquids in the vessel. Examples of alternative systems include automatic tank gauging systems and lease automatic custody transfer or LACT units. The Colorado regulation requires operators to employ these types of alternative systems for new or modified storage vessels, and our proposal would require the same in New Mexico.
What are some of the benefits of Clean Air Advocates' proposed storage vessel measurement mission?
So the Clean Air Advocates proposal reduces emissions using systems that have been used for years in the field at a reasonable cost to industry. And as I'll describe later, it also has important safety benefits, which I'll discuss briefly. So the Colorado Air Pollution Control Division included an analysis of the storage vessel measurement system regulation in the regulatory analysis that went in with those regulations in 2019. Using cost data for automatic tank gauging systems, This analysis showed that the use of a measurement system is generally cost-effective, and the cost effectiveness will increase the more often measurement occurs. In general, measurement is carried out each time liquid is transferred from the tank to a truck, a process often referred to as load out. If a measurement occurs 100 times per year, the requirement will reduce VOC emissions from an 8-tank battery by 5.1 tons per year, which works out to a cost of about $3,447 per ton. If measurement occurs once per day, then the requirement would reduce emissions by 18.6 tons for such a tank battery at a cost of $944 per ton. Colorado's, when the Air Pollution Control Division put forth this analysis, they stated that these numbers were, quote, extremely conservative insofar as the new and modified facilities that will be subject to these requirements will likely have production at such a level where load out happens more often than even one time per day. In addition, the division found that the Air Pollution Control Division found that equipment costs would be lower for owners and operators who use storage vessel measurement system at multiple facilities, and that the use of such a system would provide benefits to owners and operators by increasing the accuracy of measurement. But the benefits of that benefit was also not included in the division's cost analysis.
And Dr. McCabe, does the use of this type of system have safety co-benefits?
Yes, it does. The National Institute of Occupational Safety and Health and the Occupational Safety and Health Administration jointly issued a hazard alert in February 2016, explaining that the agencies had identified health and safety risks to workers who manually gauge or sample fluids on production and flowback tanks from exposure to hydrocarbon gases and vapors, exposure to oxygen deficient atmospheres, and the potential for fires and explosions. The hazard alert explained that opening tank hatches, often referred to as thief hatches, can result in the release of high concentrations of hydrocarbon gases and vapors, which can have immediate health effects, including loss of consciousness and death. It went on to survey 9 cases between 2010 and 2014 where a worker died while performing manual tank gauging. The agencies recommended use of alternative tank gauging and sampling procedures that enable workers to monitor tank fluid levels and take samples without opening the tank hatch to reduce the hazards associated with manual gauging. Clean Air Advocates' proposal would require exactly that at new and modified facilities, including an important co-benefit in terms of occupational safety at the same time that it reduces emissions of ozone-causing VOCs and other pollutants.
Thank you, Dr. McCabe. And I think I may have neglected to mention this, but we're also going to do our SIR rebuttal related to tanks. Dr. McCabe, did you review the rebuttal testimony? This proposal that was submitted by NMOGA witness John Smitherman?
Yes, I did.
Can you summarize what Mr. Smitherman had to say?
Yes, Mr. Smitherman notes that the Oil Conservation Commission's waste rule, which was adopted this year, does include a requirement to use auto gauging technology at certain new storage vessels. And so he suggested that NMED should not impose separate requirements to those already established in order to avoid conflict between agency requirements. He also characterized our proposal as requiring the use of a lease automatic custody transfer unit, a LACT unit, at all newer modified tanks, apparently in addition to requiring an automatic gauging system. He suggests that LACT units are very expensive and infeasible at sites without electric power. And he also contended that the economic analysis prepared to support the Colorado proposal underestimates the cost of installing an auto gauging system and a LACT unit.
Dr. McCabe, do you agree that because the Oil Conservation Commission adopted a rule that already requires auto gauging for certain new storage tanks, that NMED does not need to address this issue?
No, the OCC rule is a good start, but it is not as protective as our proposal. There are two important differences. First, my understanding is that the OCC rule only requires the auto gauging technology to be able to measure the quantity, the amount of liquid in the tank. Our proposal, like the Colorado precedent, requires that the auto gauging technology be able to measure both the quantity and the quality of the liquids, meaning that operators would be able to collect a sample of the liquid without opening the hatch. Second, our proposal in the Colorado rule expressly forbid operators from opening thief hatches to gauge or sample tanks where auto gauging technology is required, which the OCC rule does not do.
And Dr. McCabe, I think there was a suggestion earlier that we might be prohibiting operators from ever opening their thief hatches. But is that correct?
No, the intention is to simply prohibit opening a thief hatch at a tank with an auto gauging system for the purpose of gauging the tank or sampling the liquid.
Is Mr. Smitherman correct that our proposal requires the use of a LACT unit?
No, our proposal simply requires operators to utilize a storage vessel measurement system. It doesn't require a LACT.
Thank you, Dr. McCabe. We now are going to summarize the written rebuttal on economic impacts, and this did go to a question, I believe, from Chair Sweeney. And because I have sharing privileges, I'd like to just pull up that testimony, which is Exhibit 23, Clean Air Advocates, Exhibit 23. I always get confused when I do this. Is that?
That's working.
You seeing the chart? Okay.
Yes.
So, Dr. McCabe, we have heard some dire predictions about the potential impact of this rulemaking on the oil and gas industry. Do you agree that this rule will negatively impact the industry?
No, I do not agree. We can be confident that these rules will not hamper the oil and gas industry in New Mexico. The rules that NMED proposed and the strengthened rules that we propose will require the New Mexico oil and gas industry to adopt measures similar to those required in Colorado. Most of those rules were put in place in rulemakings in February 2014, December 2017, December 2019, and between December 2020 and February 2021. Comparing the historical record of oil production and drilling from Colorado to that from other states, it is clear that neither oil production nor drilling was hampered by the Colorado rules. Excuse me. The volume of production, and especially the count of rigs, which is an indicator of drilling activity, varied tremendously over time in response to the price of oil, other economic factors, developments in technology, and the evolution of production patterns in the US. For example, the growth of activity in the Permian in recent years has pulled investment away from other states. Because of these hugely influential exogenous factors, it is helpful to compare Colorado's trajectory of rig count and oil production to other states that have not put in place similar protective regulations to reduce reduce air pollution from upstream oil and gas sites. So the first thing that I just looked at, and we described this a little bit, but it's sort of hard to describe a graph without having it in front of us. So I did discuss this a little bit on Tuesday, I believe it was. This is just looking at the rig count for Colorado since the beginning of 2012 and comparing it to North Dakota and Oklahoma. The size of the industry and the quantity of natural resources vary a lot between states. And North Dakota and Oklahoma each had about 180 to 190 rigs back in January 2012, while Colorado only had 77. So it's most informative to look at the changes in each state's rig count since the beginning of 2012. Therefore, this graph shows for each state the ratio of the rig count in each state to that state's average rig count back in January 2012. And then we just set that January 12 rig count at 100 for the purposes of the graph. So clearly, drilling activity in Colorado has tracked very closely to activity in the other two states. After Colorado put its rules in effect in February 2014, which happens to be it was right about where that line is. The rig count actually grew in Colorado, but it did in the other states too that did not put in place rules to reduce these unnecessary emissions. There are actually many changes in each state's drilling activity, but the states move quite similarly. There's simply no evidence that the drilling activity in Colorado dropped in response to the rules that Colorado put in place. And now in 2021, with all of the sets of rules in place from all 2014, 17, 19, and 2020, the ratio of present day drilling to early 2012 drilling is the same or higher in Colorado as it is in Oklahoma and North Dakota. Oil production shows the same story. Colorado there is again red. Quite simply, relative to 2012, Colorado has outpaced North Dakota and Oklahoma for oil production, despite the fact that those states don't have these rules in place. So there's simply no evidence that these rules have hampered oil production. In summary, the evidence from drilling and production statistics shows that drilling activity and oil production in Colorado weren't hampered by the protective rules that Colorado put in place. And given the similarity between the Colorado rules and the rules proposed by NMED and by environmental stakeholders, we can be confident that adoption of those rules will not lead to dire economic consequences that some stakeholders have predicted.
And Dr. McCabe, before we respond to the question that we had from the board about pneumatics, we did get a question from the board about how significant a producer Colorado is. I think that might be good to take that now.
Okay.
Do you have that information?
Yes, for both 2019 and 2020, Colorado was the #5 producer of crude oil, just behind Oklahoma and just ahead of Alaska. For 2020, Colorado was the #9 producer of gas, just behind New Mexico, which passed it that year. Colorado was #8, just ahead of New Mexico for gas production in 2019. Production of gas grew in both states in 2020, but New Mexico's gas production grew faster than Colorado's, so that's why it passed Colorado.
Thank you, Dr. McCabe. And our final question here. On Tuesday, certain members of the board, I believe it was Member Garcia, but may have been several members asked similar questions. I'd asked whether we could provide estimates of how much lower the estimated cost of pneumatic retrofit program would be if the analysis took into account the increased revenue that operators would receive from selling conserved gas and the maintenance savings that operators tend to experience when using alternatives to natural gas driven pneumatics. Could you briefly provide those estimates?
Yes. So I'll provide the estimates of the effect of those factors on the cost estimates for well pads, just because it'll be too many numbers if we try to do it in too many different types of facilities. NMED, but it'll give an idea of the fact that these factoring in these effects can be significant. So just as a reminder, NMED calculated that the cost of the retrofit program that they proposed for well pads would be $2,745 per ton of VOC. For the first issue, which is the increased revenue from the sale of conserved gas, we used the value of gas, the cost of gas that Mr. Smitherman recommended during Tuesday's testimony, which was $3.20 per MCF of gas, as representative of the net value that a producer might get, discounted from the Henry Hub price, for example. Accounting for the revenue from selling the conserved gas at this price, we find that reduces the cost of the rule by $900 per ton of VOC. And then regarding maintenance costs for facilities that handle wet gas that is more liable to condense and heavier in higher hydrocarbons, such as oil well pads, we estimate that accounting for net maintenance savings when calculating abatement cost reduces the abatement cost by $674 per ton of VOC. This net savings in maintenance cost would be smaller for facilities that handle drier gas, such as some gas well pads and gathering stations, if they handle drier gas without large amounts of condensable heavier hydrocarbons. For well pads handling the drier gas, we estimate that accounting for net maintenance and savings when calculating abatement cost reduces the abatement cost by $270 per ton of VOC.
Thank you, Dr. McCabe. That concludes my direct questioning. So we will now make Dr. McCabe available for cross-examination.
Thank you very much, Mr. Bach and Dr. McCabe. If you're a party in this action and you have questions of him, please turn on your camera. I see Mr. Curtis, and then I see Mr. DeSalin. Mr. Curtis, go ahead.
Thank you. Good afternoon, Dr. McCabe. I just have a few questions here. So you testified a little bit on your storage vessel measurement proposal, and I believe you said that the intent of that was to not preclude opening the fee patch in all cases. Is that correct?
Yes, sir.
Okay. And so as an example, if an operator needs to open a tank to perform maintenance or to fix a leak, open the fee patch to do that, you would think that would be an appropriate step. Is that correct?
Yeah, I mean, it's hard to speculate about individual cases, but our intention is certainly not to preclude ever opening the thief hatch.
So in cases of required maintenance to ensure the continued operation of the tank or to address leaks or things along those lines, you think that's inappropriate and within the scope of what you proposed?
Yes, that's our intent.
You spoke quite a bit about the cost per ton analysis that was done for tanks at 2 tons per year in Colorado. At the time that analysis was conducted, had the impacts that the worldwide pandemic and related supply shortages have had on the economy, had those taken effect by that time, and was that taken into account by Colorado?
No, it preceded the pandemic.
And so if, as others have testified, the costs and supply shortages associated have increased, you would anticipate that to affect the cost per ton effectiveness of the proposal, correct?
I would expect some impact on cost.
Okay, thank you. You provided a little bit of context on drilling activity to suggest that the oil and gas industry has not been impacted by the regulatory provisions. Did you provide any data on the amount of rigs that have been, the amount of wells that have been plugged and abandoned since the rules have been passed?
No, that data is very challenging to work with. It's very noisy data, and it's very hard to, if you look at a typical source and try to discern the number of wells that have been plugged and abandoned, you get negative numbers in certain years, and it's very difficult to get reliable data for abandonment.
So drilling activity doesn't really tell us anything about a rule's impact on existing gas and oil wells. Is that correct?
I don't think that's a fair statement. If a company decides to make an investment in drilling, which is substantial, they're looking forward over the anticipated life of that well and anticipating that it's a worthwhile investment. And they certainly are going to consider operational costs for the well and the value of the well over time since many of them sell wells. So no, I think that's too sweeping a statement.
And do you recall Mr. Smitherman's testimony that when an oil and gas company is considering the economics of a project, they're looking at individual sites and considering whether that particular asset will provide a return on investment? Do you recall that testimony?
I'm sorry, sir, I don't recall it at this time. There's a lot of, this is a voluminous record.
A lot going on. Okay, thank you. You provided some information on your cost estimates of what money we would save, that the oil and gas industry would save as a result of capturing additional emissions from pneumatics. Can I ask what emission factor you used when conducting that analysis?
Yes, that's using the NMED emissions factors.
And specifically for intermittent pneumatics, what emission factor was used for that?
I believe that's the 13.5 SCF per hour.
And just to refresh my memory, you endorsed the use of 3.5 standard cubic foot per hour in the Colorado rulemaking. Is that correct?
Yes, we did, as a conservative analysis of emissions in that particular state.
I don't think I have any other questions. Thank you, Dr. McCabe.
Welcome.
Thank you, Mr. Curtis. Mr. DeSalen?
Thank you, Madam Hearing Officer. Can you hear me okay?
Yes, sir.
Great. Good afternoon, Dr. McCabe. I just have a very quick question for you. Is it your understanding that the New Mexico Environmental Law Center also supports the proposal to require automatic gauging systems or other alternative systems on tanks?
Yes, sir.
Thank you. That's all I have.
Thank you, Mr. DeSalen. Any other parties with questions? No? I'll turn now to the board for their questions. If you're an attendee on this platform and have a question, please reach out through the chat, Madam Chair.
Good afternoon, Madam Hearing Officer, and thank you, Dr. McCabe, for your testimony. I don't have any questions at this time.
Thank you. Vice Chair Trujillo Davis.
I don't have any follow-up questions either. Thank you.
Thank you. Member Cates?
No questions here. Thank you.
Thank you. Member Bitzer? I think that was no questions. Member Garcia?
No questions, thank you, but I really appreciate the graphs showing the comparison of Colorado's activity post rule. Thank you.
And Member Honker?
No questions, thank you.
All right, thank you. Mr. Bach, did any of the questioning by Mr. Curtis prompt redirect?
No redirect.
All right, thank you, Mr. Bach. Thank you, Dr. McCabe, for your testimony. Let's see, Casey Spall did reach out through chat to say that CDG has no further rebuttal on this topic from either Mr. Kim or Ms. Cooper. So I believe we would return to the department. If there's any disagreement on that, please turn on your camera. No? Okay, so let's come back at 5 of 3. Oh, there's Mr. Heiser.
Madam Hearing Officer, Mr. Smitherman, who's our witness on one of the issues that was just touched on, is not here today, so I would need to just give him a brief review of what was said and see if he would need to say anything. So I'll check with him as soon as I can and let you know.
All righty, thank you. Ms. Katz, you're nodding your head. I take it we can return at 5 of 3 with the department. Yes, okay, thank you. 5 of 3.